Hi, everyone. My name is Avery Dial. I'm a shareholder at Fowler White Burnett. I practice commercial litigation, insurance coverage, bad faith, and professional liability defense.
Good morning. My name is Seth Lehrman. I'm the partner at Farmer Jeff V. Weissing, and we're sisters of Lehrman. I have a consumer class action practice and happy to be here today. Thank you.
I'm Michael Goldstein. I'm president of Land Infotech. We're an IT services firm, and we specialize in cybersecurity.
Jack Tudor. I'm a circuit court civil judge and the administrative judge of circuit civil.
All right. So, hello, everyone. Let's see. So, we're going to start off with this slide. I think it's a great quote by the former FBI director. There are two types of companies: those that have been hacked and those that will be. Rory made a very good point when he started off, and that is that law is a business. So, as a business, you are not immune to being hacked. In fact, as we'll go into later, law firms are being specifically targeted because they're seen as soft targets. And you've probably all heard about some of these major hacks, and I hope you don't ignore them, but I think we have a tendency as lawyers to ignore things that happen to other businesses because we think that we're a little bit different than other businesses. But I'm here today to suggest that whatever it is that's in your skill set as an attorney, whether it's taking depositions, due diligence, transactions, oral argument, research, writing, you need to add security to that skill set. You are basically a warehouse, a holder of personal information for your clients, even if you don't think you are. A lot of people do personal injury, defense or plaintiff's work. You have medical records. That's an obvious one. But I would say that even if you take payments from people, you have their credit card numbers, you have checks, you have information that has value. And as an attorney, you have a heightened duty to your clients. But even if you weren't an attorney, just as a normal business, you would have a duty to protect that information and to make sure that it didn't get out to the public. So this is a rough outline of what we're going to talk about today. Some data breach risk facing attorneys, recent breaches, legal and professional responsibilities to try to tie in to show you where the bar rules apply where the bar rules apply that would set forth the standard to show that attorneys must protect their data. We're going to talk briefly about insurance and protocols and some of the coverages that you may want to make sure that you have in order to protect yourself against data breach. And we're going to talk about some of the court administrative rules regarding redaction and filing personal information. Okay, so this is an outline of the risk. So if you divide it into broad categories, you have your internal and your external threats. And the internal threat, I think the most common that we would deal with is the negligent internal threat. Someone who throws medical records, who throws financial records in the trash rather than the shredder. That's probably going to be the most common type of breach. But then you have other risk internally, people that are disgruntled, maybe they just want to be destructive and destroy data, people who are doing something for a financial reason, embezzlement, stealing a client list, other trade secrets to sell to competitors, and then you have your whistleblowers, your Snowdens. And then as far as external threats, you've got what they call hacktivists, people who are on righteous missions or perceived self-righteous missions like Anonymous or other groups. You've got competitors and opponents that may hack. And I know we've heard all these great stories of corporate espionage, and you think it doesn't happen in the legal world, but later on I'll show you an example of where it's actually happened in the legal world. Of course, organized crime, state-sponsored hackers. we've heard a lot recently that maybe Russia was behind the DNC hacks, or that North Korea was behind the Sony hack. Personally, I think that's particularly potent, because what do you do to protect yourself against the threat of highly trained military computer scientists hacking you? Like, it's almost impossible to stop. And then you have just the intellectually curious. And I had this quote here from Kevin Mitnick, who was a world famous hacker who was rumored to have been able to, and this is in the era when you actually had to pay for long distance. He was rumored to be able to whistle the tones into a telephone to get free long distance service, because he could emulate the sounds of the tones that were running in the background at the phone company. But he says, in the past I was hacking for the curiosity and the thrill to get a bite of the forbidden fruit of knowledge. Okay, so you may have somebody sitting in your network at this moment. Hackers are very patient. It is shown that it may take between 98 days to 6 months for you to discover a breach, and it may even be years before that data is used. A lot of what they do is they may skim data wholesale. Like, for instance, you take payments by credit card, they get into your system, they get the credit card data, and they sit on it for years before it's ever used, which makes detecting the breach more difficult, because it's so attenuated in time. And let's move on. All right. So here's some of the consequences of breaches. You've obviously got reputation damage, lawsuits from victims of a breach, which there are some developments in the law now where they're finding that victims of breach have standing. There was kind of a long-running tradition where courts were tossing these cases because they said that there were no actual damages yet, but now that trend's turning around. Bar sanctions, judicial sanctions, and other government enforcement. The FTC enforces data breach issues. State attorneys general, because they follow the FTC, and Health and Human Services with regard to HIPAA. Their Office of Civil Rights has been doing some enforcement actions.
If I could just ask a quick question. What type of, just so everyone in the audience is all, following exactly where we are with the importance of this topic, what are the top 3 sources or types of data or information that law firms have that these criminals or these whistleblowers or whatever you are looking for from law firms?
I think probably
The goal that law firms have.
the goal that a lot of law firms have is information about mergers and acquisitions. I think that's what a lot of the big hacks, like there was a series of 50 firms that were hacked, larger firms, where the criminals were looking for info on mergers and acquisitions in an effort to manipulate the stock market. Another thing that trade secrets, intellectual property, that's gold. And just personal information regarding clients, name, social security numbers, and that's common. Like, even if you're not doing M&A, even if you're not doing patent work, you've got a ton of personal information, and it's just like they say, a thief would rather break into a house without a dog or an alarm. They see law firms as soft targets. It's hard to hack Bank of America, but it's easier to hack a law firm with Bank of America's files inside. So you don't have to penetrate Bank of America to get to the info. You just have to get to the lawyers. So
Every lawyer representing a client could potentially have social security information, bank account information.
correct.
And also what we're seeing in a lot of our clients, and again, some of you might represent small firms, some of you might represent large firms. What we see many times is a lot of smaller firms sitting out there saying, what do they want with my data? Maybe you're not a Fowl White, or maybe you're not a Schutz and Bowen on that side of it. The other thing that we are seeing is that if you do represent, specifically a few of our clients that represent Allstate, State Farm, we've gotten specific, binders of documents from State Farm that literally are requiring our law firm clients, which are small clients, to comply with close to HIPAA standards, where they have to go out there and talk about and produce it. In the old days, it would be that they would pull a firm like us in just to sign something and say, yes, you have a good backup. Yes, you have disaster recovery. Yes, it's a protected Wi-Fi. Now they're actually asking for proof of this. So one of our large clients that goes out there represents Allstate. Last year, they sent me a document that I had to have the attorneys translate. Then we had to go back to Allstate to actually have them define what the data was. And then they gave us 6 months to sign the papers, and on the 7th month, they came in and they picked 3 out of the 10 things that we said that we were compliant in to actually test. So the firm had to go out there and hire us to go out there and prove that they had email encryption was one of them, that their data itself was encrypted, and that anybody that had a laptop really did have an encrypted hard drive, and if they went out to Starbucks, they were using encrypted Wi-Fi. So it's everybody that's out there.
And another one of these consequences is remediation and mitigation costs. So if you are hacked, you have to, under certain statutes, you may have to notify people. You may have to bring in a technical consultant to figure out what happened with the breach. You may have to offer credit monitoring. There's a lot of things that you may need to do to mitigate this this breach, and those costs can, depending on the size of the breach, be very large. We discussed why attack law firms. So in terms of types of breaches, you've got traditional hacking, outside hacker, kind of using the computer system to move into your system and gain access. Physical theft, somebody just takes a laptop, takes a flash drive. Point of sale attacks, which can be as simple as someone putting a skimmer on a gas pump that records the credit card data as the cards are used, or it could be somebody accessing through the back end, which was the case with Target, I know, and I believe Home Depot also, that they had a vendor that had access, and that vendor's portal was really the weak point that allowed access to the system. And I would like to use that as an example. For lawyers also, you need to vet your vendors. So with your experts with whom you're sharing private information, you need to have business associate agreements with them because they could be the weak link to you being breached in the same way that this vendor was the weak link for Target. Yes?
When a hacker actually hits your computer, wouldn't your virus protection also notify you of something?
I'll allow Michael to address that one.
No is really the short answer on that. I mean, I will tell you that one of the newest things that we're seeing out there is smartphone attacks. So I'll use an example of that. On an iPhone, we all think that us and people in the Mac world are protected. So one of the newer type of hacks that you get, and we find a lot of this with Gmail users. So if you're a Gmail user, occasionally you get one of those security texts. And lots of times that's actually not really a security text. So what happens on an iDevice, if they hack you, is that they attach themselves to your texts, your contacts. So in general, think of it this way. I know what I put in my texts that are out there. Sometimes my son asks for the Netflix password. Think of things that you go out there. And one of the biggest challenges that we're having with our firms right now is that you're communicating client data back and forth to those clients because they want instantaneous access. So when our firms are reviewing their policies, it's very difficult on an iDevice for a firm to track the texts. So if you're putting client confidential information into a text, and later on it has to be discovered without putting a subpoena out to AT&T or Apple and trying to get it, if the phone was wiped, it's very hard. So these type of devices, you definitely will not get something.
Don't they have a program that they can put in your office computer to protect you from that?
So I'll just say this, that yes, there's a lot of products that you can put out there, but our philosophy, and I've been working with firms for 30 years, and it hasn't changed. If there's a lock, there's a key. So in general, there are ways to protect yourself, but really, I hate to say it, that we're going back down to basics, because right now, passwords are the biggest source of hacks into your system. So I could have the best alarm system in my house, and if my wife leaves the window open. So in general, we're going back to education of employees, making sure that even though you have the best security in place there, if I know that you always use the same password, and I get information because I read your Facebook account or your LinkedIn account and figure out what your password is, what good is it? So you have to think of general things that would go out there to protect yourself.
Yeah, Michael, you better pass out your brochure to everybody here.
You know, I wanted to follow on what Michael was talking about. Michael referenced that, you know, an instance where a client requested he send us some information, and it fits in well with what Avery's talking about now in terms of the buy-in. I mean, it's listening to all these recent data breaches, including ones that have targeted lawyers or law firms. As practitioners or managers of law firms, it doesn't have us concerned about the prospect of ourselves being targets of data breach. I don't know what would cause that concern for us to have that. You know, so on the one hand, we have to balance the request from the client to send us information with other professional responsibilities that we have. So just before I pass it back to Avery and the rest of the panel, I just wanted to reference that, you know, under the Florida Professional Rules of Responsibility, we have a kind of a tandem of rules. We have 4-1.1 that says we've got to be competent. And then we have 4-1.6 that imposes on us a responsibility to preserve the confidentiality of client information. So, and when we read those rules, we read the comments to the rules, we read the ethics opinions interpreting those rules, what we find is that we as practitioners have been charged now with being technology experts, but we have to be knowledgeable, reasonably knowledgeable about technology. We have to consult people who have more knowledge than we do to make the right decisions. And this becomes a significant issue to the extent we want to use any type of technology, whether it's email, texting, whether we want to use cloud-based or other software services. So we don't necessarily have to be experts on the use of these applications, but we do need to make a reasonable inquiry into whether we are satisfying our obligation under 4-1.6 in protecting and safeguarding client data when we decide to use those applications. So as Avery continues to talk about these recent hacks, whether they're law firm hacks or others, I'm always processing that through the lens of these professional rules of responsibility, these professional responsibilities that we have, as well as, not to mention, statutory duties that we may have under Florida Information Protection Act, HIPAA, or whatever other statutes apply to the personal information.
If I may, everybody out here is thinking one question right now. What is a reasonable standard of care?
Well,
Any thoughts on that?
well,
I'll take a stab at that. I think that the rules. I think you could formulate a standard of care based on one, the bar rules, and there's a case recently, FTC versus Wyndham, not a law firm, obviously Wyndham's hotels, but in the FTC versus Wyndham case, basically the FTC found that Wyndham needed encryption, they needed to have passwords, that you need to actually do what you say you're doing in your privacy policy and your security policy. If your website says that transactions are secured if somebody pays by a credit card, or they say that, or it says that data is encrypted, then it needs to be. And finally, in FTC v. Wyndham, you need to be state of the art. And we know the technology moves fast, but if you're still running Windows 98, you probably have a problem. So I've looked at, and this is just me personally, I've kind of looked at FTC versus Wyndham as the standard of care, because it's been laid out as the standard of care for all businesses. I would say that at a minimum, law firms need to meet the standard of care for a general business. And there's probably an argument that as attorneys, we even have a higher standard. But I think FTC v. Wyndham is probably, the tenets laid out in that case are probably the minimum. It's 799 F3rd 236.
Michael, any thoughts on that?
I think that what we're recommending to our firms, and we've had this challenge over 30 years, is that if I tell you that you have to encrypt your email, and we'll talk about maybe at the partner level, we always explain that what the client is actually going to receive. So if I send you an encrypted email, we would expect that the client on the other side of that would have to actually pick a password, go out and do something to get that email. Now, lots of times I get summoned back to the management committee and say, what did we do? My client's unhappy because they have to actually do these extra steps, where before I would push a button. So we're fighting that battle basically now, of letting them understand that this is what secures you, and this is what you have to do, and it is the standard. And we're going back, and yes, state of the art is, in your mind, because literally, this iPhone 7 came out, is it better than the 6? Do I have to go out? Is it more secure? So in reality, we are really going back to basics, of going back to the firms and saying, when was the last time that you reviewed your data usage policy, your privacy policy? Many firms haven't on that end of it, and we really have to adjust it, because in this form of this new world of ransomware, the ability that someone could take over and lock your systems. You look at Hollywood Hospital out in California. They say that it cost them $17,000, but data that we looked at probably cost them $6-7 million. But think about you walking into your hospital. You have the need to access some patient records, and all of a sudden they tell you that the data isn't there. It's encrypted. You can't get to that. So there's policies that have to really be updated, and we are really just going back to basics of passwords, how you use your data, what you do in Starbucks, and USB drives.
Stay away from Starbucks.
In evaluating Dropbox or other, cloud providers, the ethics opinion 12-3 provides kind of a roadmap of sorts. How do you, as a practitioner, read the rules together, understand how you discharge your obligations? Because now when you talk about cloud services, now you're talking about dealing with non-attorneys outside your firm. And we know that as lawyers, we can engage service providers outside our firm, but we need to take reasonable precautions to make sure that they're doing their work in a way that's consistent with our obligations under professional rules. So when you hire Michael Goldstein and his firm, that's great. You can meet Michael, you can speak with him, you know what you're dealing with. But when you're dealing with some entity that you contact online and you don't have a personal arrangement with them, a personal contact with them otherwise, how do you assess that? So I'd encourage people to look at 12-3, but basically, what you get into is you have to make this reasonable inquiry. You have to assess the terms and conditions that are found on the cloud provider's website. You have to make some inquiry into how they're securing your data that's going to be stored by them. The rule says, or the comment to the rule says, I think 4-1.6, that if you take reasonable precautions to safeguard your data to prevent unauthorized disclosure or inadvertent access to it by others, if you take those reasonable precautions but there's still a breach, you haven't violated the rule. Now, that might provide comfort to you in some instance, but I don't think any of us wants to be in a situation where, having done a good job for a client and representing them, we now have to approach them and say, listen, we have some bad news to share with you, right? But good news, we exercise reasonable precautions. But despite that, your data's out there and the Russian mafia has it.
What I'm saying is that no matter how reasonable you are in trying to prevent it, they're smarter than we are. They can always get inside.
Well, they're going to
There is
listen
no
to that.
privacy because of the computer age.
But encryption does solve a lot of those issues. And where you talked about Dropbox or other cloud-type products, our clients will go in the extra step where they buy encrypted-type products to encrypt what might be up in Dropbox, OneDrive, any of those cloud services. And it's also important to go out there and make sure that you're using a paid product. Because the epidemic that we're seeing in a lot of the larger firms is a lot of the younger associates come out of law school using their free copy of Dropbox, and the firm has no control of those documents. So we're helping them audit to be able to look at what they're using, and some of the firms are telling us that, hey, we can't stop them from using this right now because we don't offer, we don't have a vetted solution to go out there and give them to replace what's there. So I think it's important to, as you said, look at what they're using, look at that policy, and you can go the extra step because there are a lot of third parties that utilize encryption where you hold the keys. It's not reliant on the cloud provider to hold those keys.
Excellent practice point.
I don't know what encryption is because I've never used it and I'm not in ISIS. Can you tell me?
We see you right here.
With all we have to know and all the stuff we have to do, we're also required to remember the password for encryption so that we can get to our files. How are we supposed to do all this?
There you go.
He has a brochure in the car. Is there a question?
Why is the rationale for making this so much more difficult than the mail? You steal somebody's mail, it's a federal crime. Why not the same?
Wonderful. Panelists?
Like, why is it not a crime? It is a crime to hack. Right. Yeah, they're just more difficult to catch.
The Russian mafia could easily get into your phone versus the mail. I just had a question, Your Honor. Do you have any thoughts about what a jury might be thinking about the standard of care?
On what?
Do you have any experiences on this? What jurors are thinking?
On data breaches?
Yes.
None. Had no lawsuits, had nothing about it. It's, what little bit we get of this is probably more in electronic discovery disputes, but we don't get any of this data breach stuff from the
It's not
judicial
getting
standard.
there.
Well, I mean, you know, we get the same emails that everybody else gets. The Florida Bar warns us not to open stuff up even at the courthouse with stuff that we get over there because of malicious things that are attached to these emails. But beyond that, this is not something that we really have anything directly with. This is a law firm issue.
Very good. Another question?
David.
Sir.
As for ultimate law firm liability, have any cases that we know of as a cause of action for legal malpractice been upheld by any courts as to data breaches in Florida or beyond? And then two, are legal malpractice insurance policies containing exclusions, or do we see that coming in the future?
Well, hold on. I'll go forward to my to the insurance slide. I'll go forward to the insurance slide and just address insurance in general. And to answer your first question, I am unaware of a cause of action for legal malpractice for data breach. If the accusation, I guess it would matter how the complaint was phrased, because I imagine if the accusation was phrased such that the law firm was being sued for not protecting data, then does that fall under the definition of professional services in a professional liability policy? So maybe it wouldn't, but I would say in general, don't rely on your CGL or your professional liability policy. No offense to Florida Lawyers Mutual, I don't know. Maybe they have some endorsements that would address this, but in general, you should.
We're excluded. We do.
Yeah.
You get cyber coverage.
So, but make sure that you do have specific cyber coverage and don't rely on your main policy, on your main PL or your main CGL policy. Get the endorsement if they have it, like Florida Lawyers Mutual does. They have a cyber endorsement. Get the endorsement and make sure that you have specific coverages.
I guess
One
the
of the-
summary is again, look at your coverage. If you're
Right.
a practitioner and see what products are out there, whether your malpractice carrier is going to provide that or someone else.
I will throw out there, and the reason it's important to have this separate coverage, because a lot of what was just described probably would fall into professional services. But there's a whole second part of cyber liability, which is the notification, the first party part that you need to deal with that won't be covered under professional liability policy. So I would encourage you, in our policy, we do attach a separate limit of liability that's completely distinct from our coverage. But if you don't have a cyber policy, really you should look at one.
We see that all the time. So again, the summary is get a separate policy.
And then just to put a rough number on it, last year we had a large client that called us and 7,000 of their documents showed up on Google. It turned out that it was the scans directory. I'm sure everybody has a general directory. And Opposing counsel pointed it out the night before. The next morning, we had the Secret Service in there. We had 2 forensics experts looking out there, and luckily there weren't any client documents that were accessed. But I will tell you that over $250,000 later in just professional fees for them to isolate what documents might or might not have been touched. And luckily, the client documents that were up there were never accessed. The forensic expert put that in place. So that was just pure fees of roughly $250,000 for 6596. That's how many documents, 6,596 documents that just showed up in a Google search.
And there's a case where the Department of Health and Human Services, the Division of Civil Rights, Office of Civil Rights at Health and Human Services, brought a case against a pharmacy in Denver called Cornell Pharmacy, and somebody at Cornell Pharmacy threw away 1,600 records in a trash can, non-shredded, and they ended up settling with Health and Human Services for $125,000. So just that easy, you know, somebody just throwing away some records could end up, you know, you're paying a couple $100,000. But with that note, I think we're gonna move on, because something I think that we should address that everybody that will affect everybody, especially every litigator at least, the way that you file things in the courts. And the rules that you have to live up to, and Judge Tudor's going to address that.
Okay, well, you know, to answer your question more directly, just because we haven't had some of these cases, I was looking through some of these materials that they provided us, and I could certainly envision, especially if you're in the bigger law firms, that this is coming down the road, because if you're handling major class action cases, or you're handling a major business case between 2 national or multi-million-dollar companies, and your company is hacked and you don't have sufficient safeguards, I could certainly see them suing the law firm. Also, in looking through some of these materials, because I was wondering what the heck I had to do with the topic here, legal malpractice, you could see even the small practitioners, those of you who practice family, those of you who have business practices, general civil practices, the world's changed with electronic filing. With respect to what you can file and what you must redact before you file it. So I could see, in many instances, even small practitioners, if you're in a divorce case and you're filing a bunch of things that these folks who cull the internet to gain access for identity theft, that you could be on the hook maybe for a legal malpractice case if your client was, if it could be established that the materials they obtained off the court filings that you were supposed to keep confidential ended up in the hands of somebody wanting to get new identity on you. How many of you ever read the rules of judicial administration? Well, you don't count, Judge Lynch. You don't count. We got about half the room. I know when I was practicing law, I think the only time I ever read them was when I wanted to recuse Lenny Fleet one time to see what the rules were. So I don't think many. Yeah, that's all right. He's not around anymore. So I never really read these very carefully, and I think most practitioners don't, but I think you should. I mean, if you go back, can you go to that slide, the basic slide here? It's 2.425. It designates what must be limited in a format, and it talks about the initials of a person known to be a minor, year of a birth of a person's birth date. You may not file any portion of a social security number, a bank account number, credit card number, charge account number. So where do those come from? I think most of those are in family or in the business context. Those are things you cannot and should not be filing in the court file. And then if you go to the next slide on the 4 digits of any, they minimize, and I'm not going to go through all of them, but they talk about things like your taxpayer ID number, if you're in a business, your driver's license number, passport numbers. I see people filing passports, copies of the passports, in the court file that I have sua sponte redacted with my clerk, because that's just ripe for information that shouldn't be in there. And then, of course, you've got your financial information, brokerage information, loan account. There are some exceptions, of course, and one of the exceptions is if it's material to the case that you're in. However, honestly, I don't see what the insurance policy number or some of these actual numbers are material to my decision in the case. So I think they'd be hard pressed unless there was some kind of a conflict between the policies or who signed what, maybe, as to why you would be filing the actual numbers on some of these things. And then if you skip forward to 2.425, you can file truncated versions of email addresses, computer usernames, passwords, personal ID. There are exceptions, as I just said. There are a lot of exceptions under the rules. Obviously, anything relating to the court itself or an administrative or agency filing, those are exempted. Birth dates of a minor when the birth date is necessary for the court to establish subject matter jurisdiction, or possibly I could see paternity issues in the family court context. Obviously, if you're dealing with a minor, if you look through these rules, pretty much don't put their name anywhere. Put their initials or some truncated abbreviation, however you want to do it. But if you go through these rules, anything dealing with a person's date of birth and a minor is exempted. There are some exceptions, as I said. There's too many of them really to go through in a panel like this. So what happens, you asked a question too about what can happen if you do this. Obviously, you can be sued for legal malpractice. That's the topic here today. If you don't comply with the rules, and for instance, if you're representing a business, I can see that if you file, I'm in the business court, so I have a lot of disputes with businesses. I have a major case now where 3 or 4 investment bankers are trying to buy a particular company, and there's all this competitive advantage between the 3 companies if the other person gets to know what the bids are. So all of that stuff is confidential. They're doing confidential filings on all of that. Trade secrets are a major issue in the business court. That's something you have to protect all the time. So what happens if you do this? It's generally not going to be, you could do it, I guess, as the lawyer, as the filing party, by just simply being negligent and simply not paying attention to what the rules require you not to do. But I think the more likely of it is that the other side is filing this stuff on the other side of maybe a divorce case, maybe inadvertently, maybe intentionally, putting out for financial information, social security numbers, dates of birth of the children, things like that, that we didn't have to worry about too much when we were doing paper filings. And the advent of this, I think, is so different because right now, if you go to the courthouse and you gear up your phone, you can get access to Odyssey, which is the clerk's website, and you can see everything. You can see every filing, you can see every document, unless it's got a confidential designation by it. You can see everything. In the old days, when the newspapers or anybody wanted to go see something about a domestic violence case or an untoward person or a public figure, you had to come over and you had to park and you had to go find the court file if you could find it and lug through the paper. Now it's all very accessible and it's very easy, and I think that's why the courts have kind of adopted some of these judicial administration rules to protect the privacy of people who are embedded in these court filings. So what happens if you violate the rule? It's pretty clear here. It says upon a motion by a party or interested person or sua sponte by us, the court may order remedies, sanctions, or both for violations of this subdivision. Following a notice and opportunity to be heard. The court may impose sanctions if the filing was not made in good faith. So there are remedies available to the judge sua sponte or by the filing of one of the people involved in the case if you violate these rules. The second part of this, which is not on the slides, which I deal with a lot, as I said, in business, and I think a lot of my colleagues in circuit civil deal with it, is the notice of filing confidential information within a court filing. And I urge you all that do this kind of work or do business especially to look at these rules, specifically what you're required to do, how you're permitted to redact it, so you just don't want to potentially endanger your client to information being on the public domain that otherwise should be confidential and protected.
Thank you.
How are we for time? How are we for time, Brady?
Oh, another 5-10 minutes.
Okay. So,
5 minutes and then 5 minutes for question.
all right. So, another interesting case I wanted to show was in California, a workers' comp carrier hired an investigator to look into a case, and that investigator realized that the claimant's attorney's website had a security flaw. So the investigator ended up downloading 30,000 attorney-client privilege client intake forms that the carrier then had in its possession. So over time, people started, I think it started with maybe a judge noticed that one of the defense attorneys had this file, this internal file, and then there were some inquiries into how people got this file. And it's kind of exploded. There's two separate lawsuits going on in California right now based on these allegations. So obviously there's ethical problems on the defense side of the case, but on the claimant side of the case, they had weak security, and that could possibly be a problem for them. Well, it is a problem for them. So don't think that we are immune to corporate espionage or having our opposition try to hack our systems in this forum, as attorneys in a competitive sense.
That sounds like Richard Nixon.
Yes.
That was an intentional act by the insurance company's agent to get information, whereas the failure of the law firm to protect is negligence.
Correct.
So there's two defendants in this type of act. Is that what you're saying? Or even a third, the investigator.
Right. Well, the suit that was brought wasn't the claimant's attorneys aren't defendants in the suit, but I think they could be defendants in another suit down the line. The suit that was brought against the insurance company, the investigator, and I think another like intermediary entity.
The lesson learned is keep your dirty tricks out of litigation. Very good.
And don't and I guess in general, something that we've seen with the election and the hacks, just don't write an email you don't want as Exhibit A to a complaint, right? I think that's a good tactic. We would like to think that everything we do is, even if it is secure, that it will never get out. But I think current times and has shown us that that's not the case.
Well, I have a question then for the panel. What should you do if you suspect, you're a lawyer and you have your insured, your client, and you suspect the other side has somehow obtained illegally data breach or some other means, private and confidential information? What are your obligations as a lawyer then?
Well, at that point, I would obviously
You don't
advise.
have real proof, but you suspect.
Well, obviously advise the client, and then I would pursue a course of discovery to determine whether or not that actually happened. In the California cases, the investigator who did the hack was deposed and admitted at his deposition that he downloaded the.
What other duties do you have? Do you have to inform the bar? Do you bring it to the judge's attention in camera? Yeah, obviously, you don't want to.
Oh, sure, I would.
A motion that might be
If I may,
involving other breaches.
look, if I suspect,
Establishing them.
if I had a reasonable basis to expect there was some misconduct by opposing counsel, I think I'd start off with a phone call to them or a letter to them. Certainly would result in a letter to them. But, aside from that kind of hypothetical, I would say something that's a lot more practical is that I know that we're taking a look at, because we handle plaintiffs' personal injury cases, we represent sex abuse victims in civil lawsuits, we handle consumer class action cases. We have a lot of personal information that we have to protect. So one threshold thing is, do we need this personal information? Do we have to have possession of this? If we don't, give it back to the client. Get it out of here. If we do need to have possession of personal information, maybe it doesn't need to be in a form that's on some type of network resource. And this is why I need to get Michael Starr and talk to him immediately. If it is maintained in an electronic format on a network resource, is it encrypted? Is there other safeguards? So I think there's a series of considerations that we have to take as practitioners. The starting one is, do we even need to have possession of this?
Do you bring it to the judge's
I have a case exactly like that, and it's in a different format. It's still before me, but it didn't come from the lawyers. What happened was they engaged in electronic discovery, and then after they did electronic discovery, they showed up at a deposition. And when they showed up at a deposition, the corporation who'd produced all the electronic discovery, they were confronting the witness with 4 emails that had never been produced by anyone. So now, all of a sudden, it's the suspicion that the lawyer was holding them on the other side, which it turned out that allegedly, some corporate insider who was favorable to the plaintiff's position culled back through the same set of electronic materials that they were supposed to produce these emails from, gave them to the plaintiff, and then they showed up at this deposition. They filed a case in federal court against the guy. I think they called the FBI on this guy. And so it's a mishmash of a nightmare to unravel at this stage.
You had a corporate mole
Yes,
producing
it was-
discovery through back channels.
Right.
And now it's in your lap.
And three of the emails were very kind of determinative of what's going on in the dispute. And so there's two things at play. One is, did the corporation who was supposed to produce this hide it? And the second was, how did this guy get his hands on this electronic material from inside, which he shouldn't have had access to?
Wow, so do you deal with sanctions?
I'm dealing with everything right now.
Collusion?
I have no idea what I'm going to do with this.
We have a panel of experts with you. But the bigger issue then is what you were saying is, on top of everything else, why didn't the corporation
Well,
produce
that's,
this in the first place?
so you've got two competing interests here. You've got the alleged bad guys who didn't produce it, the alleged bad guy who did find it and then produced it improperly, and now you got me in the middle of it trying to unravel it. So I don't know where this is going to go. I know they've got a competing case now in federal court against this gentleman, and so this case started out as kind of a routine, mundane business dispute, and now it's unraveled into bar issues with the lawyers, allegedly theft of internal data, allegedly failing to produce materials that was otherwise discoverable. So who knows where it's going to go.
I hope you're not going to be a witness in the federal court.
Maybe I'll retire before it resolves
That's a good
itself.
option. Well, excellent. And I guess another question is, are you obligated to report violations like that to the bar?
Well, that's what initially, of course, the defendant raised with the plaintiff's lawyer was, why didn't you bring this to the court's attention? Where did you get this? Now, the lawyer's embroiled in all of these questions from an ethical standpoint. How did you get it? Where did it come from? Why didn't you disclose that you had it? Was it possibly subject to some clawback if it was in the ESI, the original ESI, which it wasn't? And so now the lawyer has got himself in a bit of a pickle with respect to the documents and how he used them at this deposition when the other side didn't know they existed.
Any thoughts on, again, being a professional versus being a business versus representing your client and not breaking the law? Thoughts, gentlemen? Going away presents? You guys are looking at me like,
Well,
I'm not touching that with a 10-foot pole.
Well,
Well,
my
and the-
speech to all the lawyers is, I mean, I cannot believe that anybody would be risking their bar license on any of this. This is just one lawsuit and one adventure, and you better come straight forward out with it. You better disclose it to the judge or your colleague, let it come right out front. It's always the conspiracy or the idea that you're hiding something that gets everybody in trouble, as we see from what's going on in the elections right now, Judge Lynch.
Exactly. It sounds like, not to get political, but it sounds like, emails on a private server.
Well, I don't know.
Well, thank you. Much appreciated.
Thanks, guys.